My name's Ken Carlson. I'm an attorney specializing in tenant rights since 1980. This is the next in a series brought to you by the caltenantlaw.com website. Today, we're going to talk about eviction for non-payment of rent, or more specifically, how you win a case like that. Contrary to popular belief, winning an eviction for non-payment is the easiest kind of case for a tenant to win. The primary reason is there are so many moving parts to go wrong for the landlord, and you have so many rights, not only rent control, but special laws that have existed for a long time. Let's get into it. I understand how you feel. You feel like this guy. It's all coming down on you at once. Whatever the circumstances were, like you lost your job because of COVID, a divorce, illness, accident, your boss went out of business, things that were unplanned and unfair. But here you are. You have no money and you don't know what you're going to do. Being evicted for non-payment just seems like part of a downward spiral. It's easy to get into victim mode because you don't know what to do. Well, snap out of it. Something told you that there has to be a chance, which is why you researched and you're watching this. Let's talk about something you probably didn't realize. This is an eviction case. Because we're talking about taking away your home or business, the law is construed much more strictly against the landlord than in other kinds of cases. If you owed $1,000 and somebody sues you in, say, small claims court, if you're entitled to a $1 credit, the judge can say, fine, pay the $9.99. That's not the way it works in an eviction case. You get a 3-day notice to pay rent or quit for $1,000, but you're entitled to a $1 credit. You win. Because you don't owe $1,000, you only owe $9.99. Here's another one you've probably never heard of. Right after the Civil War, California's first legislature enacted a bunch of laws, including Civil Code 1511. It was made under the circumstances of the Civil War, disrupting a lot of businesses. It provides that if you're unable to pay because of government regulation, like our government shutting down all the businesses in California, you are excused from paying. The government stepped in and said, we're not going to allow you to work, stay home. Okay, well, now that most of COVID has passed, you still may be affected by that same set of circumstances, where the law has shut down your boss's business or your business, and you haven't been able to gain an income again. So, under Civil Code 1511, you're not in breach, and you cannot be evicted for non-payment of rent. Late fees are illegal in residential tenancies. The landlord doesn't go to jail for fraud for trying to steal this money from you because, well, they're landlords and they get away with a lot of things under the law. But this is one where they don't. A late fee is a liquidated damage under Civil Code section 1671, and it can only be charged under certain circumstances. The most that the landlord could charge is the interest they lose, about 1/36,500th of your monthly rent per day, about a nickel or a dime, but not an automatic $50 or $100. So, if you've paid these late fees in the past, even 10 years ago, they carry forward to today. If you can't pay this month's rent, so you're entitled to, say, a $100 credit for the past late fee, even if you've accumulated $50,000 of unpaid rent, you win the case because a long time ago, you paid late fees. Too bad. Here's another common situation. Let's say there's something wrong with your place, and the landlord doesn't fix it. So after you've waited a reasonable time after telling him, you go ahead and fix it yourself. You say, I need it fixed. You spend $5.26. You're entitled to a credit for that. So, if to the extent that you made a repair in the past, even if it's only $5.26, it carries forward to today. So here comes the landlord who says you owe $20,000 in back rent, and you say, no, I don't. Here's my receipt for $5.26. And you could win the case simply because you repaired and the landlord didn't reimburse you for it. Here's a strategy that you can use right now. If an eviction case has not been filed yet, or even notice has been given, but you know that it's coming up, you can write to the landlord and say, hey, could you fix this thing in my unit? Because it's been broken a long time, and I appreciate your doing that. The landlord says, well, I'm not going to fix anything unless you pay your rent. Okay, so you go ahead and fix it. You repair and deduct under Civil Code 1942. You have the legal right to do that. And then you say, okay, I spent $5.26. Can you reimburse me? And the landlord says, hell no, I'm not going to give you any money. You owe me. All right, save that receipt. Because when it comes to the eviction trial, you want to wait for that head-slapping moment when you present the judge with your receipt for $5.26 that the landlord wouldn't allow you to deduct from your rent, and you win the case. Inspectors. Similar to that is where there's a technical problem that's brought to the attention of an inspector for the city building department or the county health department. The problem affects habitability. You call them up and they come out. They say that's a violation and they cite the landlord. If the landlord doesn't fix it within 35 days, you have the legal right to withhold rent as a means of forcing them to fix it. You win because the landlord didn't comply with the order from the inspector. Here's a similar problem that involves more serious things. Let's say, for example, you don't have heat, or the door won't close, or there's a rat infestation, or cockroaches, low water pressure, slow drainage, things like that. You have the right, if it's bad enough, to withhold your rent and stay in possession. It's called the implied warranty of habitability. You can download the habitability worksheet from the caltenantlaw.com website to help you identify all the problems in your unit and organize the information. Of course, the landlord says, oh, you're not going to do that. I'm going to evict you. Well, guess what? You win the case because you're entitled to withhold the rent under the implied warranty of habitability as a means of getting it fixed. The judge or jury can decide that with those conditions, a much lower amount was due, and you only have to pay that lower amount. Now, when a place is built, the contractor who's making it has to go to the building department and get permits, and the construction is checked periodically as it's coming along. And then, finally, a certificate of occupancy is issued by the government agency to say you now have a house with a garage. Well, after that's done, landlords who think they're going to get away with something may turn that garage or accessory building into a dwelling unit, taking advantage of the housing shortage. So even though it's supposed to be a garage, they turn it into an apartment. Well, guess what? Because they didn't go through the process and it's not supposed to be there, it's an illegal unit. If the unit is illegal, so is the rental agreement to rent it. So, no rent is due, and you're entitled to get all the money that you've paid back. You'll find that same kind of situation where the landlord has a big house and decides they're going to convert it into a duplex. They can't do that without a permit. So, if you live in one of those places, you don't owe any rent, and the landlord has to pay you back. You win the eviction case. You'd be surprised how many mistakes the landlords make just in miscalculation of the amount of rent due. You may have been entitled to a free month's rent, or you may have started paying rent in the middle of the month, but your rent wasn't prorated. You may have overpaid by mistake, or they mistakenly charged you for something. The amount that you're actually obligated to pay at any given point might be less than the landlord is now demanding, simply because they goofed up on the math. That kind of thing happened with the COVID Relief Fund money. Congress gave trillions of dollars to the landlord across America straight into the landlord's pockets. In California, it's known as the Tenant Relief Act. The idea was to prevent landlords from evicting tenants for non-payment of rent. Landlords got greedy, and they started including rents that they weren't entitled to, like after they've terminated your tenancy, or illegal rent increases, late fees, even money for illegal dwellings. They collected all that money, but then didn't account for it correctly in your tenant ledger. Then they come back after you for more. The result is they claim that you owe more than you legally do. You can make your own ledger showing that you owe less than he's claiming and win the case because of the landlord's dishonesty. Here's a situation where you have, say, a 1-year lease, and you've decided, well, now it's not really worth what I was paying, but the landlord wants even more money in a new lease. When your lease ends, you're not agreeing to pay the new amount just by staying there. You're not agreeing to pay any amount until you do come to an agreement. You don't owe any rent. Of course, he might be able to evict you for still being there, but he can't evict you for non-payment of rent. Here's a situation that arose as a result of COVID. A lot of people just weren't able to pay the rent at all since March of 2020. So the landlord has been giving a few non-payment notices, but you haven't been able to pay any of them. They don't care if you're unemployed, pay or get out. And they keep giving you these notices. Well, guess what? After the first notice is given, the lease is dead. They killed it. How much rent is due on a dead lease? 0. It does not come back to life like a zombie because they give you a new notice that says this notice supersedes all prior notices. No, it doesn't. You would have to agree for them to withdraw the prior notices, and you don't. So, they gave you a 3-day notice to pay rent or quit in, say, September of 2020, and you haven't paid them any rent since to reinstate the tenancy. There is no rental agreement. No rent is due. You still owe something for the reasonable value of the place, but they can't put it in a 3-day notice to pay rent or quit and evict you for not paying it. Here's something that's increasingly common because of COVID. Those of you who have been unable to pay rent for a long period of time might get a huge 3-day notice to pay rent or quit going back more than a year. Well, guess what? You win that case because the 3-day notice cannot go back any farther than 1 year of the rent that's due. Oh, they can file a small claims case or other kinds of case to go after that, but it can't be included in the 3-day notice. You win because the 3-day notice demands more than 1 year's rent. Here's something that comes up every once in a while. Let's say your friend is the tenant who lets you live there, but you get named in an eviction case for non-payment of rent. Well, if you're not on the lease, you don't owe the rent. They can't evict you for non-payment of rent. At least you can get out from under the obligation to pay. That'll often arise where the friend leaves, but you're still there. They can't evict you for non-payment of rent. You don't owe it. You can win the case because of an illegal rent increase in the past. This happens a lot in rent-controlled situations. There are other laws that limit the legal amount of a rent increase, like the Tenant Protection Act, which sets a maximum of 10% per year. You can also win the case because the landlord didn't give you enough notice of the increase. Up to 10% needs a 30-day written notice on paper, and beyond 10%, it must be a 60-day notice. A phone, text, or email doesn't count. If they didn't give the right notice, the legal rent stays the same, even if the landlord bullies you to pay the illegal amount. When it comes to eviction now, you show that the illegal increase in the past resulted in a recalculation of amounts legally due. So the landlord is demanding too much, and you win. The increased rent could be the landlord's retaliation for your complaints, or other assertion of rights, like calling the building inspector. If you can show that the rent was increased in retaliation for your exercise of legal rights, the increase is illegal, and an eviction based upon that retaliatory increased amount is also illegal. There are even more ways that you can win an eviction case for non-payment of rent, including some technicalities, but they're a little too boring to discuss here. The important thing is that you understand that the mere fact that you haven't paid the rent, especially because you didn't have the money or other circumstances, doesn't mean you're going to lose the case. Know that there are defenses that you can raise and that you can win because you're not in the wrong, the landlord is.